Where we are, Mr. Scott, you're up. 7 minutes or thereabouts.
Thank you, Mr. Chair, and thank you, Mr. Côté. So I won't summarize even what you've said, but it seems very clear you've given a whole bunch of reasons why the symbiotic relationship between your office and the rest of Elections Canada is one of the benefits of staying there. You've indicated a number of other dangers of moving to the DPP. So my question is, can you see any problem with the current location of your office within the structure of the Elections Canada, any problem that is being solved by moving your office to the office of the DPP?
I do not. But what I would add is this. If the preoccupations about possible conflict of interest in our being within Elections Canada is one that is deemed to be that requiring an adjustment or a fix, it seems to me that a much better approach would be to put into the Canada Elections Act the same kind of statutory guarantee to my office and to my tenure as would be made now if we were to move to the DPP. To me, that would address both issues. My issue about remaining within Elections Canada to have quick access and better understanding of the issues, and at the same time would address the perception that apparently some people have that there may be a lack of independence or a lack of security of tenure.
Yes, apparently some people do have that perception, despite all evidence to the contrary. So basically you're saying anything done in this act that is a benefit, for example, security of tenure is built into C-23 in a way that it doesn't exist right now for your office. There's no reason that couldn't have been done by keeping your office within Elections Canada, for example.
That, I think, would be my view indeed.
Exactly. Okay, thank you. I'm assuming you were consulted by the minister, so do you have any kind of an insight into truly why he would want to move your office?
I was not consulted by the minister on the bill.
You were not consulted?
I was not.
Okay. Shall we move on to another issue? You and the Chief Electoral Officer have both made very good cases in a couple of reports, you in your 2012-13 report, for the need for a power to be able to apply to a judge to secure a judicial order to compel testimony of witnesses. In your report, you detailed all the different ways in which witnesses do not cooperate and make investigations difficult. Is any of this coming from direct experience of recent investigations with witnesses? For example, with respect to the use of fraudulent calls during 2011, did you encounter any of these problems that have informed your view of the need for the power to compel witnesses?
First, Mr. Chair, as I said, I will not comment on any investigations, though in answer to the question that was put to me, I will state on the record that there have indeed been cases, a number of them, where in the performance of our investigative powers, in our investigative work, we have come across witnesses who have simply, I shouldn't say witnesses, but people who had information that was relevant to our investigation who have simply refused to talk to us. That has happened more than once.
Okay.
Including in matters of some significance.
Right. I commend page 13 of your report to everybody for your overall description of the kinds of problems that are presented by that. Now, I believe you've emphasized it in a way that cannot be, you say, I believe it is essential to give the Commissioner the ability to seek a court order to compel testimony. You talk about the safeguards that would exist with that along the lines of the Competition Act. And you say, quote, I want to be absolutely clear, if this amendment is not made, investigations will continue to take time, and in some cases a lot of time, and importantly, some will simply abort due to our inability to get at the facts. Is it the case that any investigations, no particular one, that before your office might have to be aborted, or because of the lack of this power, would this power help in some investigations that you might otherwise have to close?
This power would greatly help, and as I said, we've had a number of instances where witnesses, in our view, or individuals having relevant information for our investigations have refused to talk. And so I do think that it is essential, if investigations are to be conducted diligently, if results are to be known soon enough, and if we are to get at the bottom of things, without this power, we will simply not be able to do that.
Okay. If I could just move on to one other aspect. There's a few things in the Act that everybody has heard about. The fact that you have a duty to inform people that are being investigated, subject to an exception. The fact you can't talk about investigations, subject to an exception, but that exception doesn't include when an investigation is closed. When it's closed, you won't be able to say anything. There's a bunch of things that actually seem to be fetters, new fetters. You have to have a reasonable ground to suspect an offense has been committed in order to investigate. The minister suggests that was a mistake. But there's another one here I'm just wondering what you would have to say about, which is, am I right in thinking that at the moment, in the structure of the Elections Canada, you have the CEO has delegated to you the signing authority from the Consolidated Revenue Fund so that you can hire temporary investigators, forensic specialists, and that kind of stuff. Is that correct?
I currently have this statutory power, which, by the way, and it's a welcome addition or part of this bill, this is maintained now. I will continue, if the bill is passed as is, to have access to the
Yes, you will, but with the approval of the DPP. Is that correct? So the question is there any reason why we couldn't write into the bill the fact that you alone would have the direct signing authority in order to have access to the statutory fund for temporary investigators?
I think that there is some perhaps refinement to the way in which the government expense system works that calls for a deputy head, the accounting officer of a department, or in the case of Elections Canada, the CEO, to have final sign-off. But certainly, within the framework as it exists now, when I have had to have recourse to funds from the Consolidated Revenue Funds, this has always gone through without any problems. And so that's what I would say on that.
Thank you.
Thank you. Thank you, Mr. Scott. Mr. Lamoureux, 7 minutes, please.
Yes, thank you, Mr. Chair. Mr. Côté, in listening to you, what you do is you reinforce in my mind just how bad and much of how this legislation, C-23, is a destructive force to democracy here in Canada. This is not a step forward. This is a significant step backwards. I feel insulted to the degree in which you weren't even consulted, you said, in regards to your position as the commissioner and having that position transferred over out of Elections Canada. I think that you've been exceptionally clear. What I had a few questions that I'd like to get on the record with you. In and out scandal, robocalls, overspending, cheating. These are things that the public as a whole feel has taken place in the last election. There is a general feeling of public confidence and a lack thereof because of the thousands of phone calls that were made because of the last election. There's this huge expectation that you as the commissioner is going to be able to get to the bottom of a lot of these very important issues. Not asking you to comment on any specific issue, but what I'm thinking about is going forward. If this legislation were to pass without amendments such as compelling a witness, would you clearly state that it would in fact make it more difficult for you to acquire any sort of a prosecution?
Mr. Chair, I don't think I would phrase it the way this has been stated, but I would say is that the current scheme as it exists should be and must be improved so that we have more tools in our box. And what I find is that in Bill C-23, in spite of the fact that the CEO and myself have called for this additional power, I have to, of course, note that that additional power is not being given to us.
Right. You state on page 7 of the presentation, and importantly, some, and you're referring to files, some will simply abort due to our inability to get at the facts.
Yes, I have said that.
That tells me that if someone's going to violate a law, there's a very good chance that you're going to have to abort because of your inability to get to the facts. And the reason why you can't do that is because you have individuals that make a mockery of of our Elections Act. All they have to say is, I'm not interested to assist you, because you cannot compel.
Mr. Chair, what I would say is that I think the words that appear in my opening remarks have been carefully chosen. What I would say is that some investigations would abort because of our inability to get at the facts.
Now, both you and I understand the Chief Electoral Officer felt it was important that you have the ability to compel. In your presentation, you make reference that there are many other organizations, independent associations, that have the ability to compel. They don't even have to go to a court. You're requesting the ability to appeal to a court in order to get someone to compel.
That's correct. And what we are saying is that what we have put forward is a recommendation that we have a scheme that's very similar to what is in the Competition Act. So that, as the member just said, we would apply to a judge, and a judge would sit between us and the citizen and would decide whether or not, in the circumstances of the case, they would decide to give us the order that we were seeking. And the member is quite right that in some other regulated areas, in particular perhaps in the securities world, the head of the organization has the power himself or herself to issue those orders.
That's right. And I think it's important that we repeat what I think was something that you made a statement at your opening remarks. In 1974, when your office was actually created, it was felt at that time that it would go to the Department of Justice, but then it moved and evolved to get outside of the Department of Justice because it wanted, or there was this perception that the Government of Canada might have some influence, versus if it goes to Elections Canada, it would have not only be perceived, but in real terms, based on what you said, would be truly that much more independent.
That's the history of the provision indeed. And if I may, Mr. Chair, I'd like to add something here. So Parliament of Canada decided, in order to ensure fair competition, to give the Commissioner of Competition that power. And I think one way of looking at this would be to say that if we want to have fair elections, as opposed to fair competition, why would we not give, or why would Parliament not give to the Commissioner the same kind of power that the other commissioners have in order to ensure fair competition? It seems to me that the set of values at play are at least equivalent, and therefore it seems to me that Parliament would certainly be consistent with itself if it decided to do for fair elections what it has chosen to do quite clearly for fair competition.
Yeah, it would seem to me that in essence this bill is going to weaken your ability to be able to get justice when an election law is violated, and your office is going to become even that much more costly because you're going to have to set up special groups to deal with Elections Canada. Is that a fair assessment?
There will certainly be inefficiencies if our office is transferred over to the office of the DPP. In terms of what I referred to before, in terms of acquiring the information and communicating the information back and forth between the two organizations. And if the toolbox is not made more complete by way of giving us the ability to apply for an order to compel, then yes, investigations will continue, in some cases to be long or extremely long.
More costly, less prosecutions is a very likely scenario, and the public loss of confidence in terms of the independence of your office. True?
Well, yeah, I've made my point on these things, and I would not necessarily adopt the way in which you've stated the issue, but I think that, that's essentially what I have said, but not exactly what you said.
Have you had the opportunity to express your thoughts directly to the Minister?
No.
Have you made any inquiries with the Minister that you would like to share your thoughts with the Minister?
No.
Okay. Can you give us some sort of an indication as to now that many people are aware of the fact that all you have to do is just say no, and then they don't have to provide testimony, do you believe that that will in fact going forward weaken the law as that gets better known?
It will not help.
It will not help.